Remember when I told you all you'd be hearing from my lawyer? So, thank you for coming tonight. I want to welcome all of you to this event brought to you proudly by the Federal Society here at UCLA. I'd like to especially thank our faculty advisor, Professor Sander, Presidents Brian Fallis, Audrey Shepard, fellow board members, my esteemed father. Thank you. Hope you enjoy where your tuition dollars are going. 504 days ago, thousands of Hamas and Palestinian terrorists slaughtered over 1,200 Jews in the most horrific way. I'd be remiss if I did not recognize that it has been a difficult day for Israelis, Jews, and all peace-loving people. Last night, the evil of Hamas exceeded what we could have imagined. The coffins of the Bivas children were paraded like trophies before throngs of people who brought their children to watch as candy was passed out. If murdering Ariel Kafir and their mother Shiri wasn't enough, the coffins were locked, mislabeled, and filled with propaganda. May God avenge their blood. Here at UCLA, sick Jew haters ripped down hostage posters that were put up on the Jilsa board and tore them down over and over again. God forbid someone see that babies were stolen. Soon after October 7th, calls for intifada could be heard across campus and behind us right here in Shapiro Courtyard. In October of 2023, the Jilsa Jewish Law Student Association sent an email to the student body to explain to those hateful and foolish students that were spewing Iranian and Qatari propaganda what exactly intifada meant to Jewish students. We clarified that intifada, a term chanted on campus, terrifies Jewish students because we recall the suicide bombings of the Second Intifada in the early 2000s that killed over 1,000 Jews. We hope to provide some context to the words our classmates were repeating mindlessly. Personally, I was in Israel in December of 2001, walking down the popular Ben Yehuda pedestrian mall, just hours before Hamas set off 2 bombs that killed 11 and injured 188. If I'd been there a couple more hours, and didn't have to rush to make a flight, who knows what could have happened. When your idiot classmates chant to globalize intifada, know what this means. You may not have heard it, but bombings happened today in Israel. 3 buses exploded, 2 more buses were found with 15-kilogram bombs. Hamas has already claimed credit. Just to convert 15 kilograms to a unit of measurement that will resonate with us Americans, that's about 4.5 bald eagles. In another miracle performed by God above, the buses are empty. Apparently, they were set with alarm clocks that were set for AM instead of PM, so the idiots should have used pagers. All right, in UCLA, Jewish students have been, in comparison, what we've been going through is not all that bad. But many hate-filled rallies here on campus culminated in the encampment that started on April 25th and enforced a Jew exclusion zone, where they stopped Jewish students and faculty, including me, from accessing the encampment and other parts of campus unless we denied Israel's right to exist. They built barriers, used checkpoints, and locked arms to prevent Jews from walking through, and even issued wristbands to those who had been approved. Meanwhile, UCLA leadership, some might say feckless, those entrusted to ensure the safety of students, told campus police to stand down, ceding control over public university property to anti-Semitic militants. Even worse, they aided and abetted the mob by adding barriers and security to keep Jews out. Recently, UCLA put an interim suspension on the student chapter that organized these illegal rallies and encampments. This was after they harassed a UC Regent and his family in the early morning at his home. It was great to see a smidgen of backbone from UCLA. I just wonder why it took only for when the mob, the violent mob, literally came to their doorstep that they felt the need to actually suspend these groups, not when they were attacking students. I also wonder when UCLA will actually enforce their policies. They certainly didn't this past Tuesday, when another rally was held against school policy, which featured drums, a loudspeaker with chants for intifada, the ever-present inverted red triangle, a poster glorifying Sinwar. They blocked traffic, they pulled the fire alarm in the math and science building. Thank God our learning wasn't disturbed. And I was also shoved, elbowed, and had a drum slammed into me when I tried to retrieve my USA and Israeli flag that had been stolen. So, with the help of 3 law firms, I and my 3 brave plaintiffs, and one of them is here, Eden, filed a lawsuit against UCLA to stop the university from aiding and abetting such bigotry again. Thankfully, in August, a federal judge, Mark Scarsi, blocked UCLA from allowing and assisting anti-Semitism on campus, calling UCLA's actions abhorrent and unimaginable. Jewish students are safer on campus because lawyers that aren't Jewish said, this is important. These students need our help. 3 law firms stepped up in no particular order. We have Beckett, a religious liberties law firm with a perfect win record at the Supreme Court. They have at least 2 more cases going up this term. On Friday, I think we find out if there's a third. Recently, Davis Polk and Wardwell joined the team to help as litigation continues. It seems like from interrogatories that UCLA is asking for information and contact information for anyone that I've spoken to about anti-Semitism. So all of you now have to sit for a deposition. Sorry about that. It's okay, your tax and tuition dollars are going to pay these lawyers. And the third law firm is Clement and Murphy, which brings me to Mr. Paul Clement. Mr. Clement served as the 43rd Solicitor General from 2005 to 2008, a position which he held where he was the chief lawyer representing the federal government before the Supreme Court. After his time as Solicitor General, Mr. Clement didn't slow down. He returned to private practice, eventually becoming a founding partner at Clement and Murphy, where he continues to be one of the nation's foremost appellate advocates. His record is staggering. He has argued more than 100 cases before the U.S. Supreme Court, which is a testament to his deep knowledge, strategic acumen, and persuasive abilities. His work spans across the spectrum of legal areas, from defending our God-given rights to keep and bear arms, to advocating for free speech protections, to fighting for our religious liberties. Some might say he's a bitter clinger to his God and guns, always showing his ability to navigate complex and often contentious legal landscapes with both principle and pragmatism. Please join me in extending a warm welcome to an intellectual giant, a defender of the Constitution, a true master of the art of persuasion, my lawyer, Paul Clement.
I'm going to try without the mic. If you need the mic, tell me if I'm not speaking loud enough for projecting. Thank you, Yitzy. I mean, that is a pretty tough act to follow in almost every respect. And maybe that's no accident, because one of the things that I've said on a number of occasions in a lot of different contexts about a lot of different clients is, especially when a case goes like all the way to the Supreme Court or something, the lawyers can get a lot more credit than they deserve. And the clients in any constitutional case worth its salt, the clients are the heroes. And the lawyers play an important role, and I think a role that is certainly worth going to law school to get the opportunity. I think in my own experience, having vindicated a client's constitutional rights or defended a criminal defendant, I feel like professionally that's about the best thing that you can do. But I still have all the hats off to the clients, because the clients are the real heroes. The clients are the ones that have to show a great deal of courage. In a lot of lawsuit cases, including the one in which I'm privileged to represent Yitzy and Eden, we are, to sue your law school, I don't think and nobody shows up on the first day of class thinking, 3 years. I'm going to find something. I'm going to sue these guys before I'm out of here. It takes courage to do that. The same is true with any person who is discriminated against in the workplace and decides to sue their employer. I mean, nobody starts a new job thinking, this is great, I'm going to sue these people. And so the process of deciding that you're going to take your rights and try to vindicate them is a daunting one. I think for every client that actually makes it into court, there are other people whose constitutional rights or other rights were arguably infringed or certainly infringed, who get choked, get deterred before they get to the point of filing a lawsuit. So I actually want to talk about 2 lawsuits both that involve this institution.
And I have to say, I've been privileged to speak at a lot of law schools. I've been sometimes at the Federalist Society, sometimes at the invitation of the broader law school. I still think this is probably a first, though, because I think this is the first time I've been invited to speak at a law school where I have an active lawsuit against the law school's defendant. So this is the first. So we're going to talk about that lawsuit. But I actually have another case right now where, although I'm not representing the University of California system, I'm representing some associations that the university system is a member of, and the University of California system is actually aligned with my clients as a plaintiff. So I want to talk about the two lawsuits, one where UCLA is a defendant, and the other one where the University of California system is a plaintiff. So let me start with the Yitzy suit, the suit where UCLA law is a defendant, or UCLA is a defendant. So I guess I will start with this by saying that there is a reason that and I think I can speak for my friends at the Beckett Fund, and they have a better record in the Supreme Court than I do, but I've lost a few cases in my day. But I had the privilege to be their co-counsel, and so a couple of my W's were their W's. We worked together on behalf of the Little Sisters of the Poor, talk about great clients, Little Sisters of the Poor, great clients. So I think I can speak for the Beckett Fund as well in saying that there's a reason that we got involved in this lawsuit. And it wasn't because UCLA was the only university in the country that had a problem with anti-Semitism. There were plenty of other problems at other campuses. But again, speaking for myself and I think the Beckett Fund, we came at this from a perspective of people who have spent part of our professional careers trying to vindicate free speech rights, sometimes the free speech rights of students. I think, and I was mentioning it before the talk, that free speech rights are absolutely important. Indeed, I think some of the seeds of the current problems at a number of campuses are actually produced that go back to a weakening of the commitment to sort of First Amendment values. Back when I was in law school, I think one of the things that people on the left and the right of the political spectrum could agree on was kind of free speech rights. That, nobody likes the Nazis, but the Nazis could march through Skokie. That was kind of foundational for people. And I think that there's been an erosion in that sense, and I think at the time, for a long time, I think, the commitment to free speech values was viewed as kind of a nonpartisan thing. And unfortunately, I think more recently, maybe because it's the right side of the Supreme Court that has been vindicating free speech rights, whereas when I was in law school, it was really the Justice Brennans of the world, or Justice Black going back before that, who were the champions of the First Amendment. But I think the kind of consensus about free speech rights has broken down. And I think in part because of that, there has been sort of levels of unrest, and also people have felt like certain people didn't necessarily have a right to have their views expressed. And so, given that orientation, I looked around at some of the things that were going on at some campuses, and I thought, well, that's terrible. I don't like the fact that people are saying some of these things, but they have a right to say it. And especially if it's a public university campus, they have free speech rights that are at issue, even if I don't like what they're saying. And we perceive that what happened on this campus was different. And it really gets down to that fundamental distinction that you learn about in constitutional law classes when you're talking about free speech principles, which is there's pure speech, there's conduct, there's expressive conduct, there's some things in between. But when you go from just protesting, saying things that are provocative, saying things that are unpleasant, particularly if you're saying those things in parts of a campus that are traditionally dedicated to First Amendment activity, that's protected. When you start blocking access to parts of the campus that are an integral part of the educational experience of your fellow students, that's not protected. That's harassment, that's discrimination in access to educational institutions, and that's not only is that not protected by the free speech clause of the Constitution, but it's prohibited by Title VI, which gives a non-discriminatory right to access to educational institutions. And if the basis for denying access is what the framers of the Constitution might have thought of as a religious test, then that's not only a problem under Title VI, but that's a problem under the Free Exercise Clause of the Constitution, at least if it's being essentially permitted, aided, abetted, whatever word you want to use, by a public institution. So, looking out at the universe of what was going on in a variety of campuses, what happened here was something that motivated the lawyers at Beckett and the lawyers at Clement and Murphy to want to get involved and want to file this complaint. And obviously, Yitzy's got a perspective on this as my client. I have a perspective on this as the lawyer. So in some respects, the perspective that may be most valuable is the perspective of Judge Scarsi, who is impartial member of the Article III Court. And when we first got involved, we filed our complaint, we filed our motion for preliminary injunction, and that preliminary injunction was granted by the judge. And I just wanted to just give you the first couple of lines of his opinion. And I'm quoting now from Judge Scarsi's opinion. In the year 2024, in the United States of America, in the state of California, Jewish students were excluded from portions of the UCLA campus because they refused to renounce their faith. That fact is so unimaginable and so abhorrent to our constitutional guarantee of religious freedom, it bears repeating. Jewish students were excluded from portions of the UCLA campus because they refused to renounce their faith. And so when he said it, a lot of times people say it bears repeating, but then they don't actually repeat it. Mm-hmm. Judge Scarsi said it bears repeating, and then he actually repeated it in the opinion. And so, needless to say, he granted the preliminary injunction. The university then did what I frankly expected them to do, which is to appeal to the Ninth Circuit. Because if I were representing a defendant and the district court judge said about my defendant essentially what Judge Scarsi said about the university, my advice to my client would be, get out of that district court. File an appeal. It can't get worse than this. You've got to go to the Ninth Circuit. At least you got a chance. At least you get a panel of fresh judges. So the university did that, and then they did something that I didn't see coming, which is they withdrew their appeal. And they put themselves back in Judge Scarsi's hands for the foreseeable future. So we'll see where things go from here. But a judge who begins an opinion that way, at the preliminary injunction stage, is not likely to fundamentally change his view about the law. And our complaint, well, I should have refreshed myself. We had, 9 counts in the complaint, something like that? I mean, we had constitutional counts, we had Title VI counts. We even, and I love this, we whipped out some of the great civil rights statutes in this country, like 42 USC 1985. We got a lot in that complaint. And Judge Scarsi didn't have to go beyond the single count that he said we had a likelihood of success on the merits on the free exercise claim to grant the preliminary injunction. But it's not like he said, oh, and the other 8 are losers. He basically said, I don't even have to get past this claim, because this claim has a likelihood of success. So that's the adjudicator for the foreseeable future. And I look forward to continuing to litigate this case. And I will confess, as a litigator, I look forward to continuing to litigate in Judge Scarsi's court, given the preliminary injunction. So let me talk about the second suit. And they really don't have a lot in common. But I actually think it's important to talk about both of these suits. And as you can imagine, on the second suit, since I'm aligned with the University of California system, I have a slightly more charitable view of their actions. So this case is a case that was recently filed, I think, the beginning of last week, I think, if I have my time frame correct. And it was filed in the District of Massachusetts. And this is a case that arose out of one of the many actions of the new administration in the first, I think we're at like 31 days, 32 days, something like that. It's been for lawyers in Washington who do kind of administrative law, constitutional law, left, right, whatever your perspective, it's been a whirlwind. I mean, this has been like 31 days, like I don't remember. Because usually a new administration comes in, there's a transition period, they maybe change a handful of policies, it's kind of an evolving process. I remember at the beginning of sort of the first Trump administration, the Solicitor General changed the government's position in 4 cases. Didn't do it all at once, over time, and the Solicitor General was criticized for switching positions of the government so often and so rapidly. Now, the Solicitor General in the first Trump administration, he's Noel Francisco. He's a friend of mine, so take it with a grain of salt. But I'll tell you, the great thing about those 4 changes of position is Noel went 4-0 in the Supreme Court in those cases. So in every one of those cases, he flipped the government's position from a losing position to a winning position. But that, by the tame standards of 2017, that was considered a disruptive transition with a lot of changes. What's going on now is much more rapid, many more fronts, much more going on. So one of the places where the administration has introduced a new policy by administrative rulemaking is in the area of grants, existing grants and new grants made by the National Institutes of Health, NIH, to a variety of educational institutions, including the University of California system, but across the country, public schools, private schools, and the like. And not to bore you with something that's kind of detailed, but I'll give you this much, which is these grants are usually done on a basis that is heavily negotiated and heavily institution specific. And the particular issue in these cases is the reimbursement of so-called indirect costs. And so it's easy to kind of understand if you are funding, as the federal government or NIH, research for a particular thing. Well, if you're giving a grant for that thing, the direct funding is pretty obvious. But then there's the question, like, for example, if you're giving funding for a particular lab, that lab is in a building, that lab may be part of an entire sort of kind of universe of labs in that building, and that building, like, didn't just happen. That building was built, there's a lot of investment in that, and so there is a policy of essentially reimbursing or giving grants not just for the direct costs, but for the indirect costs. And those are all heavily negotiated on institution-specific basis. But the government, late on a Friday, about 2 weeks ago, the government said, we're getting rid of all of those negotiated rates, and we're going to impose across the board a 15% reimbursement rate for indirect costs, which is much lower than most of the negotiated rates. And the universities immediately cried foul, and I think you'd say, well, I don't really know enough to know whether the universities have a good case or a bad case. Here's why the universities have, in my view, an outstanding case. The Trump administration in 2017 floated this idea in a budget proposal. At that point, they said we're going to go to 10%. So the only difference is the difference between 10 and 15%. So they floated this proposal, and Congress responded in a bipartisan supported appropriations rider that basically said you can't do that. We're going to ban you from using any appropriated funds to change the negotiated rates. I mean, the provision's this long, it's got some dense text, but that is the clear import. Don't do that, don't use any appropriated funds. And so a number of universities, including the University of California system, and 3 major organizations, including the American Association of Universities, that includes lots of members across the country, filed suit under the Administrative Procedures Act and the Constitution and that statute. And among their lawyers was yours truly. So this is the one where I'm on the side of the sort of California system. And as absolutely important as Yitzy's suit is, I also think this suit is important, because this suit does get to principles of our government and separation of powers and the like. And whether you're rooting for the new administration or you were rooting for the last administration, I do think kind of respecting the separation of powers, respecting the Administrative Procedures Act are incredibly important things. And from the perspective of the Federalist Society that's dedicated to the rule of law, I think an affinity for sort of the proper order, the Administrative Procedures Act, the separation of powers is something that is certainly consistent with what the organization has tried to promote over the years. It's also been something that I've tried to promote in some of my own litigation over the years. And I think it's fair to say that I spent a good chunk of the last 4 years trying to, on behalf of clients, check some actions that I viewed as administrative overreaches by the Biden administration. And I think some people were a little surprised to say, okay, well, you know, Clement's been suing the Biden administration. So what's he doing suing the Trump administration? This is really weird. What's he doing? And I guess I'd like to leave you with the idea that it's not weird at all. If you're committed to the separation of powers, then it really doesn't matter who's in the executive branch at any one time. You should have your concerns if there's administrative overreach going on. And one of my favorite cases from a term or two ago that I got involved in, another set of courageous clients, was a case on behalf of some fishermen. And these commercial fishermen were being regulated by the federal government. And the federal government said, not only do you have to make space on your vessels for government monitors, but you have to pay for it. And the administrative agency did that even though the statute said nothing about making fishermen pay for the monitors that were on their ships. So that case went all the way to the Supreme Court. The Supreme Court, in a decision called Loper, vindicated my client's rights and got rid of the Chevron doctrine. Now, at the time, I think a lot of people on the left of the political spectrum shed a tear for Chevron. A lot of people on the right said, that's awesome. This is a great victory against administrative overreach in the administrative state. I think the conservatives were right to celebrate. I think my friends on the left were wrong to cry tear, even at that moment. Because if you think about some of the victims of Chevron deference, I mean, yeah, some of them were Chevrons or chemical companies who were being regulated. Some of them were commercial fishermen, and part of the reason that I was so excited about that case when I first got called about it was because I thought the fishermen in that case put a human face on an issue that just seems very abstract. But the other people who were victims of the Chevron doctrine were immigrants, because trust me, the government and the immigration courts within the government were not shy about invoking Chevron deference. Other victims, veterans, because the Veterans Appeal process is governed by a statute that is ambiguous, and you had the government happy to say that ambiguity cuts against giving benefits to veterans in these circumstances. We win, see Chevron. And the last of the troika I'll give you is Social Security beneficiaries, who also were in that same position of trying to get benefits under an ambiguous statute, being confronted not just with the government's best argument, but the follow-up argument that, well, and if our argument's even halfway decent, we get Chevron deference. So there was never a reason to think about Chevron, in my view, as a left-right issue, or Loper overruling it as a left-right issue. But I'm really hopeful that that's going to be crystal clear over the next couple of years. And my hope, and my friend here told me this is a fantasy, but my hope is that liberals are going to learn to love Loper. Because, administrative overreach is administrative overreach. And I think this case that I'm litigating right now against NIH and the government is a perfect example of this. If you believe in the separation of powers, if you believe in Congress's ability to impose more enduring solutions that don't change with each administration, then you should be concerned that the government is essentially ignoring an appropriations rider where Congress said you can't do this, and they did it anyways. And when I was arguing the Loper case, I think one of our very persuasive arguments was to say that a world with Chevron gets to a world where the governing law for lots of people change every 4 years. And the example I used, just because it was so clear, because the Supreme Court had a case involving it where they applied Chevron deference, and it's, it's not the single most important issue in the world, but it's a good illustration of it, is broadband regulation. Whether broadband should be regulated in a way that's got a very light touch, or whether it can be regulated very intensively, and the government can basically tell companies that offer broadband that they have to give it at certain rates or certain people at a discounted rate. And literally every 4 years, the government was flipping its position. Or environment is another area where Clean Air Act regulations, every 4 years. And there are all sorts of other areas of law where you could literally see that the Obama administration had overturned the Bush administration rule, the Trump administration then overturned the Obama administration rule, and then Biden administration overturned the Trump administration rule. So every 4 years, the basic rules of the road on important issues were changing. And in my view, that was a feature that, or that was not a feature, that was a bug of the Chevron deference regime, because it facilitated that. And I think by getting rid of Chevron deference, the court has gotten away from that and suggested, no, you've got to get to the right answer under the statute, and that's just it, and it doesn't change every 4 years. So with all, even if you're somebody who's kind of excited about some of the changes that happened in the last 31 days, I think you should also be willing to understand that maybe some of those moves, some of them are probably justified, some of them overreach, and you shouldn't criticize the courts if they are correctly identifying which ones are overreaches and which ones are not. And then I'll just sort of leave you with this thought and then take some questions. But I've been privileged to teach separation of powers at Georgetown Law School, which is kind of my indirect alma mater. I was a Georgetown undergrad, and I went to some law school that didn't have outdoor foosball tables and outdoor fences, so I'm a little jealous. But I went to another law school. But I've been privileged to teach at the Georgetown Law School for 20 plus years, and I've always taught separation of powers. So it's something I believe in very deeply. But one of the things I tell students is kind of one of my adages about the separation of powers is you can't really think clearly and coherently about a separation of powers issue until both sides of the political spectrum have had their oxen gored by a particular phenomenon, by a particular doctrine. And the most obvious example of that, I think, and shows my age and when I sort of grew up in Washington, but the most obvious example of that was the independent counsel statute. When the independent counsel statute was first rolled out and it was used against Republicans in the George H.W. Bush administration, the Democrats thought it was awesome. Then they saw Ken Starr and what happened to the Clinton administration, and they're like, this is a disaster, and the independent counsel statute did not get reviewed. But there are plenty of examples like that. When the other party is in the White House, nationwide injunctions seem like a great idea. When the other party is in the White House, forum shopping is a great idea. There's a Republican in the White House, welcome to the Northern District of California. If there's a Democrat in the White House, welcome to whatever district in Texas. And of course people criticize forum shopping, and then they don't. But I think the great thing is, if you have the perspective of thinking about these issues and seeing how they play out, when whatever team you're rooting for, it doesn't matter. When your team's in the White House, when your team's not in the White House, and then you can think about them coherently. So I would just close by saying, I hope for those of you that have been concerned about executive overreach, or those of you that have been concerned about sort of separation of powers issues, that in the change of administration, you use it not as an excuse to change your mind, but as an excuse to kind of test your principles and to try to separate a little bit of the wheat from the chaff and figure out what are the really good issues, what are the issues that are problematic, and I think that's how we can move forward. So thank you very much.
We had some questions that were It's gonna be like lightning round. So the first one, and 2 people asked this.
I answer questions for a living, so.
So one of them wasn't me. Who's your favorite client?
Whoa.
Lightning, come on.
Yeah.
Easy.
Yitzy. All right. It's okay to pander. Yes, thank you. You're number 2. Is he first in the pleading?
It's alphabetical order.
Yeah. That's what he told me.
What was the most strenuous case you've ever taken?
Strenuous, I would probably say McConnell against FEC. It was a case, and it literally was strenuous, because this was the challenge to the Bipartisan Campaign Reform Act, and I was defending the constitutionality of the act and the government. And this was a statute. It was very interesting, because a lot of times there's a statute that's passed, and it's debated as a policy matter, and the Constitution really doesn't figure in the congressional debates. But in the Bipartisan Campaign Reform Act and McCain-Feingold, like, the congressional debates were all about the First Amendment. And part of the compromise was that, all right, the Republicans, when they didn't have enough votes to block it, they put in a provision, and it's supposed to be late, right? Still, they put in a provision that gave direct review from the district court, a 3-judge district court, to the Supreme Court of the United States. All right, somewhere there is a volume of Fed Sup Second that is essentially entirely dedicated to the 3-judge district court. It's like thousands of pages long. 3 judges produced 4 opinions. It was just a mess. And they also sort of set this provision up so that almost anybody could challenge it all at once. So there were 11 cert petitions or appeals filed in the Supreme Court for this decision. And there literally were 11 briefs filed against the government side of this case. So the amount of paper was just enormous. And we filed a single brief, and it was one of the hardest briefs I've ever had to write, because we had to bring in so much. But I also feel like it was a strenuous but good case, because we were able to actually make this monstrosity manageable for the Supreme Court. But it was strenuous.
Sure, that probably answers the next one. What has been the hardest part about your job?
Hardest part of the job is losing for a client, and I gotta say, particularly in a criminal case. I feel like it's part of my responsibility as a generalist lawyer to take on criminal cases on occasion. But they are so much harder on a kind of personal level. I never like it when my client loses. Won't happen to you, don't worry. I never like it when my client loses. But if a corporation has to write a check, I'll still get to sleep that night. But if you're representing a criminal defendant and they're going to prison because you didn't win the appeal, you don't sleep that night.
Glad that won't happen to me.
Yeah.
All right. What case, other than mine, I'm assuming, obviously, are you most proud of arguing on behalf of?
So these questions are so tough, because cases for, at least for me, and I think for a lot of lawyers, they're like children. Like, you love them all. They're all different, and the like. I'm a big believer in religious freedom, so, I'd probably give it to the Little Sisters.
Oh, okay. Which skill in litigation do you think is the most important, and why?
Right. And why? Because oral arguments are short, briefs are long. So that's simple.
Is there an upcoming SCOTUS decision that you're looking forward to?
Yeah. Shockingly, it's a case I argued. But I argued a really interesting case earlier this year called Glossop against Oklahoma. It's a capital case, and it's an interesting case because I was arguing against sort of the imposition of the death penalty in this case, but not on behalf of the capital defendant. I was arguing for that position on behalf of the state of Oklahoma. And in this particular case, the state of Oklahoma basically confessed error in a capital case, and the Oklahoma Court of Criminal Appeals said, we don't care. We're going to reject your position. We're going to say you waived all of this, and we're going to go ahead with the execution, even though the Attorney General of the state was essentially confessing error. And so we brought that up to the Supreme Court. And so I argued, alongside Seth Waxman, who represented the criminal defendant. The court had to appoint a court-ordered amicus to defend the judgment of the Oklahoma Court of Criminal Appeals. And part of the reason I'm looking forward to it is, with some expectation, is just to make the case just this much more interesting. Justice Gorsuch is recused, so they only have 8 justices. And it would be a particularly unfortunate case, I think, for them to just say, yeah, we're equally divided, we can't decide, so we'll just default to the Oklahoma Court of Criminal Appeals.
Do you think the Supreme Court will grant cert to assault weapons ban case?
Eventually. I mean, I don't know when it'll be, but they will. The Second Amendment is obviously an area where I've been involved in litigating for a long time, and the court takes Second Amendment cases, but they never seem super excited to do it. So you have to have a couple of cert denieds on an issue before you get lucky in a case. But eventually they'll take it.
In your view, was the court's decision in Trump v. U.S. consistent with originalism?
Well, I guess I would say it's not consistent with textualism. And that's because there's no text in the Constitution that talks about presidential immunity. And, as to whether it's consistent with originalism, in a way, I guess I would say it's not consistent with originalism either, because my own best view of the matter is that the framers didn't think this issue would arise. And, in their sort of somewhat credit, it didn't arise for 230 years. So, you can't fault them too much. But I think that was really one of the hardest cases, particularly for a textualist court, because there's no text. There's no text for a good reason if you think about it. There's a reason that the Constitution has a speech or debate clause, right? Because the Constitution gives the executive the power to prosecute. And so, of course, it would be a temptation for the executive to go prosecute a bunch of senators who are voting against administration priorities. So the senators need an immunity. The framers are sitting there thinking, we're giving the prosecutorial authority to the president, so he doesn't need an immunity. He's not going to prosecute himself, is he? And I don't think they really focused on the possibility of a prosecution against a former president and what immunity to impose. So I think for a textualist court to have to address a really difficult issue without any text is a pretty tough assignment.
All right. How can we continue to advocate against anti-Semitism and prove it in the court of law?
So we can do it. I mean, unfortunately, I would say it's a target-rich environment. I wish it would be hard to litigate against anti-Semitism because we'd look around and we wouldn't see any. And so I guess I would answer the question by saying, I do think we need to pick our cases. And, to go full circle, that's part of the reason that Beckett and I were so excited about your case and your case. And there is, like anybody else, I'm a huge fan of Thurgood Marshall. But one of the things I admire about him is the strategic vision. Say the same thing about Ruth Bader Ginsburg when she was a litigator. She's bringing all these cases on behalf of 19-year-old boys in Oklahoma. What a weird way to try to vindicate the rights of women. But she understood that was the way you're going to build this sort of precedent by precedent, and you don't build good precedents by picking the hardest case and litigating that first. And so I think that's the way that you're going to have to do this, just to pick good vehicles, build the law, and that'll be positive in the end.
All right. What is your best advice for undertaking a legal advocacy career positioned against school systems or universities?
So I guess I would generalize it by saying, my advice for people that want to be litigators. I mean, if you want to be transactional lawyers, that's great. You'll probably do very well. But if you want to be a litigator, my advice to you is go litigate. Don't take the job that pays you the most, but is going to give you the fewest days in court. Find a job early in your career that's going to get you into court, that will allow you to build your skills. That's a good move for two reasons. One, you'll get better, and the second is those kind of skills are portable. You can litigate cases for the government, and then you go into private practice, and the client is going to ask you, well, how many bench trials have you had? How many jury trials have you had? How many depositions have you taken? The client's not going to care whether you did them wearing a government jersey or a public defender jersey or whatever jersey it was. You're just going to care whether you had those experiences. And I also think that if you have those experiences and they're portable, it just gives you leverage the rest of your career. I mean, we didn't get into it today, but I can't keep a job. I keep leaving big law firms and the like, but I can do it because I have these experiences, and I'm not beholden to the big law firm. Whereas if you go to a big law firm, you don't go into any place that gives you a lot of experiences that you can take to some other law firm, then you're basically beholden to the law firm. And if they tell you, no, you can't bring that kind of case here, or they tell you you got to do this for that client and you don't think it's appropriate, you're sort of stuck. Whereas if you've already, you've already been a prosecutor, you've already done 10 jury trials, if the law firm tells you to go do something stupid, you can tell them where they can go with that.
On that note, I do want to ask, when the Bruin decision came down, Kirkland kind of parted ways with Second Amendment cases. Were you upset? Were you thrilled that now you could just go out on your own? Now in retrospect, how do you think about that?
So I was very upset, and I continue to be upset, not because I'm not actually happier at Clement Murphy. First, it's just a better name. But no, I actually like the freedom to be able to take kind of any kind of case I want. I think that's particularly important for an appellate lawyer, because appellate lawyers, most clients need an appellate lawyer once in a blue moon. They don't need lots of appellate lawyers, and so you need to have a diverse sort of group of clients in order to have an appellate practice. And so if you're being told you just can never sue a bank, well, that just takes a whole swath of the potential cases you could do and takes them off the table. Or you could never do a Second Amendment case. So I'm happier, I think, in my current firm, but I'm still not happy about having to leave Kirkland. I mean, part of it was, it was my professional home for 5 years. I don't like moving. I had a bunch of stuff, and some of the stuff was still in boxes from the last law firm. But I had a bunch of stuff I had to move. It was a hassle. Had to find real estate to rent for the new office and all that kind of stuff. So it was personally a hassle. But the more serious thing that bothers me is I just don't think it's good for our profession if the big law firms aren't doing certain kinds of constitutional cases, but they're doing other kind of constitutional cases. It's there's this sort of weird sort of ghettoization of certain constitutional rights, and those you can only do at public interest firms. You can't do it at big firms. Or it really is worse than that, because it's not that you can't do certain kinds of cases. You can only do one side of certain kinds of cases. And that's just not good for the law. It's not good for those law firms in the long run. It's not good for the courts. And it's probably less important, frankly, in appellate law, because that kind of lends itself to being able to do it at public interest firms or sort of small and mighty boutiques. But some trial practice, you just need a lot of bodies. And that's hard to do in a boutique setting. And so over time, if there's certain kind of cases that require trials and only one side of those cases is going to be represented by big law, I think that's going to skew things. And so that's what bothers me. That's why I think we need to get back to a little more of the kind of ethos of the profession, a little more of that kind of John Adams flavor that will take either side of the controversy.
Well, if you need more bodies for litigation, this is my resume. How do we determine what counts as a religious belief? In this case, the belief in questioning or supporting the state of Israel.
So, great question. And I think this is one of the things that has made anti-Semitism a little, sort of harder to tackle, and unfortunately, I think has facilitated some of it, which is there's this, debate even within the Jewish community. And I'm a Catholic kid from Wisconsin, so I say this advisedly. But certainly my understanding is even within the Jewish community, there's an ongoing debate about religious identity, cultural identity, and which to emphasize. And I think that is a more prominent sort of phenomenon with sort of the Jewish sort of faith than it is an other faith. And then, just to make it one step more complicated, then you have Israel, which is a nation that has a religious and a cultural identity of its own. And, look, we got the Vatican, but, what's that? That's probably smaller than the campus here. So that doesn't, at least post, 1870, the Vatican doesn't really count. And so what that creates is this kind of three-level complexity with where people who are anti-Semitic can say, oh, no, this has nothing to do with religion. I just don't like people that are pro-Israel. Or this has nothing to do with religion, this is cultural. And it's hard because the protections for religion are sort of better developed than the protections for kind of, culture, country identity. They're all protected in the end. So it's all, in my view, kind of like just a big dodge. And I guess what I would say, at the end of the day, I think as long as the root of it all is faith, that should be enough to have it protected as kind of core religious exercise.
This, I think, came from a state senator in Oklahoma. How is the Federal Society working, because apparently you answer for them now, working to protect our democracy in light of the powers given to Elon Musk without the approval of the Senate or Congress?
So, I'm not representing the Federal Society, but this really, dovetails with what I was talking about, which is, I haven't studied the issue, I haven't litigated this, I don't know, but, is there at least an appointments clause issue here? Like, whether it's right or wrong, is there at least an appointments clause issue with what Elon's doing? He's certainly operating a lot like a principal officer of the executive branch. I don't think he's been confirmed by the Senate. So is that an issue that we should be concerned about? Or is that an issue we should just say, oh, that's just sour grapes about the last election. Elections have consequences. The consequence of this election is Elon. I'm of the view that, the former view is the one that's more consistent with the ethos of the Federalist Society.
All right, this comes from someone who's definitely not named Paul Holtzman. What are your favorite types of cases to argue? Why is the answer gun rights? And what gun rights will your upcoming arguments hopefully win for the people?
So I do love trying to vindicate the Second Amendment, and I'll talk about that. They're actually not my favorite cases. My favorite cases to argue, at least in the Supreme Court, I do love religious liberty cases. But in some ways, my favorite cases to argue in the Supreme Court are like ERISA cases and bankruptcy cases and stuff like that. And the reason is that, when I walk in and argue a Second Amendment case, how many justices walk into that court thinking, I don't have a preconception about this case? I think the number is somewhere between 0 and 9. I think it's closer to 0, right? But if you got a case, I had this case that I loved about, I think it was section 546E of the Bankruptcy Code. And, sort of avoid, fraudulent conveyances and avoidance powers of the trustee. None of the justices came into that with a preconceived notion of how they're going to decide that case. They had no priors that matter in that case. And so, as an advocate, that's a place where advocacy can really matter. Every justice is up for grabs. And in this particular case, part of the reason that I love this case is I was representing the respondent. And in the Supreme Court, since they don't have to take cases if you're representing the respondent, that generally means you're going to lose. Because most often they take a case to overturn the result below. And so we were representing the respondent. There was a lopsided circuit split in the direction of the other side, and we won 9-7. And and I'm very proud of the advocacy in that case, but I love that because those are the kind of cases where the advocacy can really make a difference. Now, why do I love Second Amendment cases, even though people have priors? It gets back to what I said about Justice Ginsburg, Justice Marshall. If you're a law geek, the idea that you discover some constitutional amendment and it's been in a time capsule for 70 years and it's in the Constitution and it's got to mean something. But the Supreme Court said something impenetrable in 1939, and then a bunch of almost every court of appeals in the country said, yeah, it's a collective right, not an individual right. So it was tucked away in the broom closet for 70 years. And in those 70 years, the Warren Court happened and the Rehnquist Court, all this stuff happened to constitutional law, yet it didn't affect directly the Second Amendment because it was off in the broom closet. And so you get an opportunity to litigate about that constitutional amendment. And just to take a concrete example, one of my Second Amendment cases in the Supreme Court was a case called McDonald, where the issue was, is the Second Amendment incorporated against the states? Well, like I went to law school in the early 90s. You read in your constitutional law books about these debates between sort of Justice Black and Justice Frankfurter about incorporation of the Bill of Rights from the 14th Amendment. You thought, well, that's interesting history. But here I got a chance to argue an incorporation case in the Supreme Court because the Second Amendment had been sort of left off in the shadows. And then you do have this ability to sort of strategically try to figure out, okay, which are the issues that are going to get there and which are the issues that are not. And I think you see this in like the cases that are coming in front of the Supreme Court now. I mean, I think we're getting to a level of maturity in the Second Amendment such that, in the first sort of decade or so, the plaintiffs, we obviously were frustrated in trying to get to the Supreme Court to review some of these cases, but we got to pick our cases for the most part. And so we could pick, wholesome grandmothers that wanted to carry. And those were our plaintiffs. But then once you get the right, recognized and incorporated against the states and effectuated in a meaningful way in Bruin, well, then gosh darn it, anybody can raise a Second Amendment argument, and then you get cases like Rahimi, where the criminal defendant is not a grandmother. And that affects the dynamics of the cases. But all of that you're dealing with, and in the Fourth Amendment or the First Amendment, it just feels like there's nothing new under the sun. Or the Second Amendment is this just kind of unique experiment in constitutional law.
Awesome. I'm going to go with one last question because I don't want to hold you too long. In your personal capacity, speaking for yourself and not for any of your clients, have you ever argued a case in which you personally would have preferred an outcome other than the one you were advocating for on behalf of the client, or have your personal preferences always aligned with your clients? If they've ever diverged, how do you process that?
So great question to end on, and the answer is all of the time. If my interests and my personal views lined up with my clients all the time, I must be like a public interest lawyer or something. My friends at Beckett, they have that luxury. They sort of pick their cases and they're always vindicating the First Amendment, free speech rights. I don't have that luxury, but I'll tell you, I don't actually want that luxury. I love my practice. I love the fact that I've been able to represent Native American tribes, but also sue Native American tribes. I love the fact that, I can, right now, I love Blue Cross Blue Shield of Louisiana because they've allowed me both to sue them and hire me and waive all the time. I love that stuff. That is to me what it's like to be a litigator and a lawyer. And so here's a really dirty secret. Not only do I like taking cases where I'm taking a position that I don't agree with, I think I do my best work in those cases, and I don't think it's an accident. Because if you think about the job of an appellate lawyer, it's basically, all right, it's a two-step process. First of all, I have to identify what are the hard questions that somebody that's skeptical of my position, or that's going to ask me. What are the hard questions a skeptic would ask me about my position? And then I have to come up with the best, most persuasive answers to those skeptical questions. So if I disagree with the position my client, I'm taking on behalf of my client, I'm halfway home. I'm there, I know all the skeptical questions because I'm a skeptic. And so it's actually easier, and I actually think the people who have the hardest time arguing cases are the true believers. Because they don't see the devastating question coming, because they don't think their case has any Achilles heel. And they can't think the way that their opponents think. Because they're just like a true believer. So I do it all the time, and I like to think those are some of my best cases.
Awesome. Thank you so much.